Can new sick leave laws apply retroactively? Imagine finding out that a new law could change your past work benefits. It might sound surprising, but sometimes new sick leave laws can impact what happened before they were passed. So, can these laws really reach back in time? Well, it depends on what the law says. Usually, laws are meant to apply from the day they become effective onward. That means they govern future events, not past ones. This is called prospective application. However, some laws do include specific language that allows them to be applied retroactively. Retroactive means the law affects rights or obligations that existed before the law was enacted. For example, during the COVID-19 pandemic, some emergency sick leave laws in states like California explicitly said they covered leave taken starting from January 1, 2021. Employers had to pay employees for sick days used before the law was passed if those days related to COVID-19. These laws clearly stated they applied retroactively, so employers had to pay for leave that happened earlier in the year. On the other hand, many new sick leave laws do not include retroactive provisions. For example, Missouri's recent paid sick time law did not mention retroactivity. That meant employers only had to follow the law from the date it became effective, not for any previous leave. The Federal Family and Medical Leave Act allows for retroactive designation of leave as protected if an employer failed to notify an employee properly. But this is about how leave is classified, not creating new rights. For employers, if a law says it applies retroactively, they need to adjust payroll and records to reflected leave taken before the law's start date. This can be tricky and might lead to extra costs or legal issues if not handled carefully. Employees can sometimes ask for back pay or credit for leave if the law states they can. The key is to read the law carefully. If it explicitly states it applies retroactively, then it does. If not, it probably only applies going forward. Retroactivity in labor law is rare and usually requires clear wording because fairness and notice are important. So, in short, new sick leave laws can apply retroactively only if the law specifically says so. Otherwise, they only affect events after their effective date. Employers should stay alert to any retroactive requirements to stay compliant and avoid surprises.